Hello, everyone, and welcome to Immigration Talk Show. I'm really happy that you have joined us here. And yes, we're going to have another very interesting session lined up, a webinar on a very important topic. But before that, let me tell you that I'm Nipasa, and I'm going to be your host for today's session. And here's a very important disclaimer before we start off. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, friends, thank you so much once again for joining us. And please feel free to join us by participating as well. You can comment whatever questions you have. Our guest attorney is going to join us very, very soon. And today's topic of discussion is why are F1 and H1B visa holders facing deportation challenges? And you could be one of them, or your loved ones could be one of them. So, friends, stay with us. I'm sure you're going to have a very, very interesting session today, a very enlightening one. So stay with us. And you can also call us up, by the way. You can call us by dialing this number 425-436-6335, and the access code is 988-888. So join us, friends, and also don't forget to hit that bell icon. We are at Immigration Talk Show on YouTube, and we are also there on Facebook, LinkedIn, Twitter, that is X, and yes, join us. We're also on Instagram. So without further ado, now please help me welcome our guest for today, Attorney Chand Parvathaneni from SPB Law Firm, Dallas, Texas. Chand, thank you so much for joining us today. It's really great to see you back again.
Thank you, Nipasa. Yeah, it's good to be back, and a lot of dynamic changes happening in the immigration world. A lot of new news coming out. We just found out yesterday that they were making some changes to the Dropbox appointments in India, and now more and more people would have to go for interviews, and they're not going to get Dropbox interview waivers. So a lot of things are changing, and this is kind of expected. Whenever we have an administration change, they always revisit policies to make things more and more streamlined, more and more better. So things are getting revamped, relooked at, and so on. So in the light of all these changes, I think it's a good time to discuss things that are relevant and to help people make sure they're in compliance with all the laws and regulations of United States.
Absolutely, very well put, Attorney Chand. And there we go. We have Amarnath Reddy join us. We are going to take up your question. Please stay with us, Amarnath. And Chand, the visa bulletin is also out for March 2025. Do you have anything to say on that too? For folks out there who are looking up for dates all the time.
Sure. So I think the dates have moved up very, very slightly. It's not a huge jump, but that being said, I think it is a very, very optimistic bulletin, because rather than not move ahead, the dates moved ahead, and finally we are seeing dates move to February, at least in the EB3 category. So at least now we are in 2013. They were stuck in 2012 for such a long time, and if you look at the last 4 years during Biden's administration, the dates have not crossed 2012. And during President Trump's administration in 2020, back then, because of COVID, it was mostly because of COVID, dates jumped to 2014, end of 2014 in October of 2020. And after that, the dates pretty much got stagnant. They actually went back. They went back to 2012. So finally, this bulletin, when I say this bulletin, the one that is the March bulletin that just got released this week, the dates went to February 1st, 2013. And what that means is, at least for the folks out who have a priority date in 2013, there is a very, very good chance that the green cards will start coming for you guys. And next couple of months, I think what I think would happen is EB3 will see a slight increase, more than likely for by a couple of months. I don't think we will come to the end of 2013 by the end of this fiscal year. That being said, at least some movement is always good. EB2 also probably will see the dates come into 2013 very soon. And whoever is eligible for interfiling, I think take advantage of interfiling, notify USCIS, because EB3, the dates are a little ahead compared to EB2, and we'll have to wait and see what's happening. On the EB5 side, because there is a lot of talk about retrogression on the EB5 side, especially for the TEA projects. But luckily, the dates for EB5 are still current for India. So if anybody wants to take advantage and be able to file for a green card immediately, right now, if somebody is born in India, pretty much the only option is EB5. EB1 is not current, EB2 is not current, EB3 is not current, EB4 is not current. EB5, the rural category, they are current. And what I would recommend is anybody that is planning or researching on EB5, this is a good time, because my opinion is in about a year, you might even see retrogression for EB5. But at least as of today, the priority date for EB5 for India is still current. So I think, in short, I think that's pretty much the summary on the March visa bulletin.
Thank you so much, Chand. And I'm sure folks out there, they were already looking forward for this. So check out for the visa bulletin for March 2025, folks. It's already out. And with that said, I think before we move on with today's topic of discussion, let's take up Amarnath's question already. Hi, sir. Actually, last year my petition got approved and I'm planning to book a consulate interview. But doubt is my qualification is BSc Computer Science with 13 years of IT experience.
Sure. I think his concern is we need a 4-year degree for H1B, and he has a 3-year degree because a BSc degree typically in India is a 3-year degree. But the good thing is you do have 13 years of IT experience. And my guess is when they filed your H1B, they used your experience and they used your 3-year degree. They did an evaluation and they moved ahead with that evaluation. So, what I would suggest you to do is when you go for your visa interview, make sure you have a copy of your work experience evaluation. And that evaluation has to come from a US professor. So, take a copy of your work experience evaluation where you have done an evaluation of your work experience plus your academics, your 3-year degree. Take that evaluation copy and also take copies of all your experience letters. And I think you'll be fine because USCIS does let you substitute experience wherever you're lacking academic um, credentials. So you need 4 years of academic years. So if you lack any years, you can always substitute with relevant experience. So definitely take your experience letters, and I think you'll be fine.
There you go, Amarnath. All the best. And yes, I think everything should be fine. Thank you, Chand, for taking that up. And Prashant, stay with us. We will take up your comments very soon. But I think without further ado, we should hop into our questions as well. So, Chand, my first question to you is with regard to our topic of discussion. Topic today is, friends, why are F1 and H1B visa holders facing deportation challenges? And yes, first up, my question to you, Chand, is what are the primary reasons, for F1 and H1B visa holders, who are at risk of deportation in the current immigration scenario, you can say?
Sure. Uh, Out on the social media, I think there's a lot of rhetoric on deportations and how people are getting arrested. But I think one thing to clarify is that in general, it is people without status, without legal stay in United States, and more than likely with some kind of a criminal background. Those are the people that are being targeted. And when you talk about F1 and H1B, most of the people came into the country after legal inspection. So they entered the port of entry, they got through a CBP inspection, and they came into the country. And majority of the folks are maintaining their valid F1 or H1B status. So again, when we talk about deportation risk, it is very rare that we see people on F1 or H1B getting deported. Usually, that being said, the most common time we see them being put in removal conditions is when people violate their visa conditions. And every visa class, every non-immigrant visa class has certain visa conditions. And what that means is uh, the visa applicant, they are supposed to adhere to those visa conditions. For example, you have a tourist. So a tourist is supposed to do activities that are relevant for tourism. He cannot start working at some place. So when we talk about F1 visa holders, the first and the foremost thing where people run into an issue is violating their visa conditions. And when we talk about visa conditions in F1, they're supposed to maintain school enrollment. And it is not any school enrollment, but it is full time school enrollment in authorized institute where they have an I-20. And if they drop below their full time status without any proper authorization, what could happen is they're out of status, and when they're out of status, the risk of deportation becomes higher. They could be put in removal proceedings. So the first and the foremost thing that F1 holders should always ensure is maintain your full-time enrollment. And if you're bachelor's, there is a certain full-time enrollment. If you're a master's student, there is a certain full-time enrollment. So check with your school DSO. Always maintain full-time enrollment. And the next common thing that we sometimes see is unauthorized employment. So F1 students, the only place F1 students can work is on campus. And even on campus, they can only work for 20 hours a week. And if they want to work outside their campus, they have to either get a proper, appropriate CPT authorization or OPT. OPT is optional practical training that people get after they graduate. So unless it is a proper, appropriate CPT or OPT and in the relevant field of study, if not, a student cannot work off campus. And if somebody is working without proper work authorization off campus, it could lead to loss of status. And that's another time we see people getting into trouble and running into issues with removal proceedings. So that is another thing. And for students, the last thing is out of status. So every student on the I-94 has something called the expiry date as D by S. D by S means duration of stay. So as long as the student is in uh, a proper university studying, or if they graduated, as long as they're on OPT, until that time, they're in valid status. And once they're done with the F1 program, there is something called grace period. And that is a 60-day grace period. And once they are done with their grace period, they're done with their completion of their degree program or their OPT program, they're supposed to leave the country. And if they do not leave, what happens is they start accumulating unlawful presence. And when they become out of status, accrue this unlawful presence, that's another trigger that could result in their deportation. So these are the common scenarios where I normally see F1 people getting into trouble and being put in removal proceedings.
Right.
And for H1B visa holders, so again, the H1B visa holders, the big thing is you get an approval to work for a company, you work in that company, you work in that role, and you work in that same location. So if somebody gets approval to work as a software developer in Dallas, they cannot work as a software developer in Austin, for example, or they cannot work as a database administrator in Dallas. They have to comply with their LCA conditions. They have to comply with their approval conditions. And if they do not do that, they are again going out of status. They're not maintaining their status. And also, if they work for another employer without proper authorization, that's also a risk. And nowadays, we see a lot of people here where they say they're working on a second job. And on the second job, they're working for an employer who's probably paying them under the table or probably without applying to USCIS. If something like that happens, that is non-compliance, and that is going to cause them to fall out of a status. So things like doing a second job, you can do it, but you have to go through the proper process and then file a concurrent H1B petition and do it. So anytime you're not complying with the terms of your H1B petition, you run a risk. And the other challenge that we see with H1B visa holders is the H1B is approved for a certain period of time, max typically 3 years. And the H1B approval will have an end date, the I-94 will have an end date. And the only way somebody can work after their end date is if they have a non-frivolous H1B petition filed with USCIS. And if the employer did not file the H1B petition, or if they forget to ask their employer to file the H1B extension, once their I-94 expires, they're overstaying. They're outside the period of authorized stay. So that's another place where H1B visa holders can get into trouble. So what everybody should do is they should always download their I-94 from CBP website. They should look at their approval copy and always make sure their most recent I-94 is current. And if their I-94 has expired, they are out of status and it could lead to a lot of issues. So for H1B visa holders, what everybody should do is make sure you know where your I-94 is, make sure what is the end date on your I-94, and always make sure your employer files an extension before your I-94 expires. So that's pretty much what we typically see on the H1B and the F1 side. And usually, again, in general, criminal convictions. So this could happen to anybody. So if anybody who's on a non-immigrant visa, there are certain crimes that are like immediately could lead to deportation. So people who are on a non-immigrant visa always should be cognizant of the rules and regulations and the criminal laws of the country. and should never engage in any kind of offenses. And some offenses like fraud, drug related crimes, violent crimes like assault, uh, they could easily lead to deportation. And whether it is F1, H1B, B1, any kind of non-immigrant visa. So always know the rules, and try not to do any kind of a criminal offense. Even if it is a simple small offense, don't do it. Even something like stealing from like a departmental store like Walmart, it could lead to huge repercussions from an immigration perspective. Driving while drunk could lead to very serious immigration repercussions, especially while you're driving and you're drunk. Say you go and hit somebody and somebody's injured, it could lead to huge problems. So criminal convictions, criminal offenses, this is something that could have huge repercussions and could lead to somebody getting deported. And what that means is, at least knowingly, make sure you don't break any kind of laws, whether state laws, federal laws, or any kind of local laws. Always stay away from offenses. And doing so, I think people in general, I think you can lead to ensure that your status is safeguarded.
Absolutely. And, you have, we've been seeing in the news as well that a lot of people, do jobs just to get paid, just to earn a little extra, but, they fall in trouble later. So I think it's very rightly put, Chan. Thank you so much for highlighting all those different risks, that uh, L1 and H1B visa holders hold.
Yeah.
Yes, Chand.
Yeah, I mean, the main thing is people who want to do two jobs, there is a legal way to do it. So USCIS does not have a problem with a person working for two different companies on H1B. It just has to be done the right way. So as long as like both the companies apply for H1, they're letting USCIS know it's a
Mm.
concurrent employment. There is absolutely no problem in doing
Okay.
multiple jobs, but it has to be done the right way. If somebody does not have the H1B file, the concurrent H1B filing done, but they work on a second job, that is when it could lead to trouble. So always check with your employer, make sure filings are done before you start working for somebody.
There you go, friends. Thank you so much, Chand. And folks out there, if you're enjoying this session, if you're resonating with what Attorney Chand has been speaking with us right now, please do not forget to hit that bell icon. We are at Immigration Talk Show on YouTube, and we are also there on Facebook, LinkedIn, and on X and on Instagram as well. So check us out, follow us, connect with us. Thank you so much, Chand. And we also got Prashant and Ankit Goyal join us. Please stay with us. We will take up your questions very, very soon. But my next question to you, Chand, is how do visa status violations, such as unauthorized work or failure to maintain full time enrollment, how do they contribute to deportation risk of F1 students?
Right. So when we talk about F1 visa typically they go through a service portal, which USCIS has access, the school DSO has access, and the school DSO is required to report changes in the service portal. And every F1 student, when they are taking a course load at a US institution, they have to take minimum of 12 credits if they are pursuing an undergraduate education, and if they're pursuing a graduate education, they're supposed to at least enroll in 9 credit hours. And again, this could vary from school to school, but every school has a certain full-time enrollment requirement. And the F1 student, they're supposed to enroll and they're supposed to make progress towards the degree. So if somebody is failing classes and they are getting into probation, it could lead to a lot of problems. So the first and foremost requirement is they have to ensure full-time requirements. And if they have any changes, always be in touch with your school DSO, the designated school official, and ensure that your service is active. And if your service is ever terminated, you will have lots of issues. Reinstatement of F1, it can be done, but it is not easy. So always you should work with your school DSO, keep him updated so your service is active. And if your service is unfortunately terminated for any reason, you have to take immediate steps to get your service reinstated. So the simple way to avoid any of the issues is always enroll in full-time enrollment, always make good progress towards your degree, don't fall into academic probation. So as long as you're getting decent grades, you're passing classes, more than likely you'll never have a problem. And the next thing is authorized employment. So authorized employment, again, you have to work on campus, which is limited to 20 hours per week. Or some people, they want to explore outside work, but go through the school, because there are curricular practical training programs, CPT programs, where while you are studying in school, you can still work outside if it is in a relevant field, it is required by your course, and you are at the school for a certain amount of time. Typically they say that you have to wait for 9 months before you can start a CPT, usually, unless immediate participation is required. And there are other certain rules for CPT. So if you want to work off campus, talk to your school DSO and check with them the programs available. Typically it is CPT or OPT. But if you don't work through CPT or OPT and you work outside, it is unauthorized employment, and that would violate your condition. And the next thing is, students should always ensure that you do not accumulate unlawful presence. And how do you accumulate unlawful presence? If you violate any of your visa conditions, you'll be considered out of status. And the minute you're out of status, what means is theoretically your F1 status is not valid, and you'll start accruing unlawful presence. And when you accumulate 180 days or more of unlawful presence, what would happen is you will have a mandatory bar for 3 years. And if your unlawful presence in US exceeds 1 year, 365 days, you will have a 10-year bar of coming back to US. So what that means is you should not fall out of status. If you don't violate your visa status, you'll not fall out of status. So the bottom line is, if you fall out of status, the timer starts, and at 180 days you'll have a bar. At 365 days, it's a longer bar. So always try not to get into that situation, and that way you don't even have any problems. And again, how does USCIS or immigration officials enforce these rules? So what they have is they have something called SEVIS, the Student and Exchange Visitor Information Systems, the SEVIS portal. And most of the schools will also give you access. If not, the school DSOs will have access. And US immigration authorities use SEVIS. They monitor the status. So in SEVIS, normally you have something called the reporting requirement. So you have to report to the school DSO certain things. And if something goes wrong, and the SEVIS, there is some violation, and the service could even terminate. And if the service gets terminated, USCIS or the immigration authorities who are enforcing immigration rules, they'll know about it. That would lead to unlawful presence trigger, and probably start of removal proceedings. So always be cautious. Always know how to check your service. Always know how to contact your school DSO to know about any service terminations and so on. And violating the terms of F1 visa, they'll not only impact your current stay, but the goal of a lot of students most of the time once they're in US is to have a career in US. They want to work in US. They want to get H1B. They want to go back to India again. They want to get H1B visa stamping and all these things. So at every point of time, when you go to get a stamping in India, or when you come back from India at the port of entry, so you have so many places where you're scrutinized. So anytime they see any kind of a violation, you're always at risk. And there are multiple ways they'll find if you have violated your status. They check your social media. They could check your social media. They sometimes take your phones at the port of entry. They can search your phones. And there are so many ways they can detect fraud and find out if somebody has done something wrong. For these reasons, the suggestion is always be aware of the rules. Don't ever do anything that could jeopardize your situation. And again, most of the F1 students, they typically try not to violate any kind of visa conditions, and most of the time it's inadvertent, it is accidental. And what that means is always get educated, and don't ever drop below the full-time enrollment, and don't ever do work off campus without proper authorization. Doing so, I think you more than likely will mitigate your risk, and not run into any trouble with USCIS, or at the port of entry with CBP, or at the consulate with Department of State.
Thank you so much, Chan, for taking that up and for that wonderful explanation. Very clearly how you've mentioned, and I hope this was very interesting for you too, friends. And don't forget to like, share, and subscribe to our channel, Immigration Talk Show. Also, Chand, I think we should quickly take up some more comments. People have been commenting. So let's not keep them waiting. Let's take up Prashant's comment. I'm an F1 student and I was recently placed in removal proceedings because my school lost SEVP certification. I had no idea this was happening. Is there any way to fix my status or transfer to another school without leaving the US?
So again, depending on what exactly is the issue, sometimes you may be able to fix it in US. Sometimes you might not be able to fix it in US. And my guess is, if your service is terminated and you're already placed in removal proceedings, you probably will have to go through an attorney to see if you can get any relief in removal proceedings. Or if not, you might probably have to go out of the country and probably get visa stamping again. Or if you already have a visa stamping, you might have to get admission in a school, take the I-20, go out of the country, and come back to get your service reinstatement. And more than likely, what that means is you'd have to take a look at what stage you are in the removal proceedings, what kind of relief you might get. And based on that, I think you'll have to take a decision. And more than likely, to me, the fastest option probably would be to get admission in a good school, go out of the country, re-enter. If you already have a visa, F1 valid visa, just re-enter with the new I-20, and then get your service activated.
Thank you so much for taking that up, Prashant. And uh, now, next one is from Ankit. I was on OPT and my employer terminated my job suddenly. I tried to find another job but ran out of the 60-day grace period. What are my options now? Can I still reinstate my F1 status?
Yeah, I think the good thing is it is not 60-day grace period. It is a lot more than that. So in OPT there are two parts: the initial OPT and then you have the STEM OPT. So in the initial OPT, you can accumulate 90 days of unemployment. It's not 60; it is 90 days. So theoretically, if you lose a job, you can have as much as 90 days of unemployment, total unemployment. And if it is initial OPT plus STEM OPT, you can have as much as 150 days of unemployment. So if you're at 60-day point, you at this point of time, you have not, I don't think you should lose your F1 status. Check with your school DSO. Your service should still be active, and try to find a job before you run out of that, you exhaust the 90-day unemployment period. So right now, I don't think you should have any problem. But again, to be on the safe side, check with your school DSO, make sure your service is active, because I don't think you require reinstatement. You should still be in valid F1 status if it is only 60 days that you lost a job.
Thank you so much, Chand, for taking that up for Ankit. And Ankit, I hope that you've gotten your answer. And if you have more questions, keep commenting. Folks, I would also like to remind you that you can join us on call. The telephone number is 425-436-6335, and the access code is 988-888. Once you're in, just speak. We will be able to hear you. So I'm looking forward for you to join us. Also, friends, don't forget to subscribe to us. We are at Immigration Talk Show on YouTube. And yes, hit the bell icon. Now, next one is Sunita. Sunita says, I violated the terms of my F1 visa by working off campus without authorization because I was struggling financially. Now, USCIS has sent me a notice to appear. Is there any legal way I can fix this without being forced to leave?
Um, so again, I think because I think a lot in your case would depend on how long has that unauthorized employment taken place, when you fell out of status, and so on. And there are some reliefs that are available. I think what you'll have to do is definitely, I think, immediately consult an attorney that is an expert in removal proceedings, deportation proceedings, because on the immigration side you have different kind of attorneys. There are some attorneys who are more experienced with USCIS filings. Then you have attorneys who are more experienced with the deportation cases, the removal proceedings, and waivers, and so on. So on your side, try to work with an attorney who is more knowledgeable on the deportation proceedings, on the removal proceedings. See if you can get some relief with the current regulations. And a lot of what is possible will depend on the kind of violation, how long that violation has happened, and so on. But that is why you have this notice to appear, where you have a chance to seek any relief that is possible. So try to use that opportunity, and make sure you use the right attorney, and try to see what kind of relief you can get in your case.
Thank you so much, Chand. And absolutely, friends, you can also contact Attorney Chand Parvathaneni, and his phone number is 817-523-8247. And you can also email Attorney Chand because every case is different and they need proper attention. So why not leave him an email at law@spblawfirm.com, and go visit www.spblawfirm.com to get to know more about Attorney Chand. Now we have more people coming in, but I will say to Nilesh and Pratap, stay with us. We'll just go for a short break, and right after the break, we will take up some more of your our questions and your comments as well. So don't go anywhere, friends. Right now, yes, this is Immigration Talk Show with me, Nipasa. Welcome back, everyone, to Immigration Talk Show. This is the second segment of our webinar we are having today with our guest, Attorney Chand Parvathaneni from SPB Law Firm, Dallas, Texas. And we are discussing about this topic, which is on the screen: why are F1 and H1B visa holders facing deportation challenges? It's been great because we have been taking up comments as well from our audience. And let me tell you, friends, that you can also join us by commenting and also by dialing this number. Our number is 425-436-6335, and the access code is 988888. Please feel free to join us, and you can ask your questions directly to Attorney Chand. Chand, I hope you're having a good time so far, taking up our questions. So this next one is
I think
sorry, Chand.
Sure. So I think the main thing is when people fall out of status, I think there are reliefs available, and some people might get relief, and some people might have a lot of other options. And the main thing is everybody's case is so unique, because sometimes when you're a student, the rules are again so different from somebody who's on H1, and again the violation might be different. So depending on the kind of violation, what has happened, how much time has progressed, so everybody might have a different kind of a solution. And in some cases, maybe taking a voluntary departure might be a solution. So always when there is a major issue, I think what I always suggest is if somebody is in removal proceedings, always you should probably find some good attorney that is local to your area, because you might need to have them go to the immigration court on your behalf and so on sometimes. So always, if somebody is in that unfortunate situation, always make sure you always get legal representation right away, and try not to do things by yourself if you are in removal proceedings.
Thank you so much, Chand. And I think we should take up Nilesh's comment now. He's saying H1B, EB2, NIW scenario in today's situation and I-485 status affected. So I don't know what is the question, but Chand, if you have anything to say on this.
Y- Yeah, I mean, again, in terms of NIW, I think, I mean, we have not seen major rule changes, but again, the priorities of the government will change. So when President Biden was in charge, he had this memo where he said artificial intelligence, AI, those jobs should be prioritized, and those are in the interest of the nation. So what would happen is, like, as President Trump goes ahead with his policies, and they can come up with some industries where they say are a priority, and what that means is some industries will probably get prioritized because they're in the interest of the nation. So those kind of things will happen. But in terms of adjudications, in the last few days, we are not hearing of anything majorly different, and the burden has not come down. You still have the same burden to prove your NIW case. And when we talk about the 485 status, if you're talking about India, the country of birth, India, when we even if it is NIW, it is still EB2, and what that means is EB2 date is still in 2012 December. So the dates are still so back. So even though you have an NIW approval, what that means is you have an I-140 approval that you can use for your H-1B extensions. But in terms of the 485, you are still looking at the priority date in the visa bulletin. So if the EB2 date is 2012, for example, for India, you still have to wait to file your 485. You can file your 485 only if the dates are current. So from that perspective, the 485 is impacted because the dates are not current. But if you're talking about just the I-140 adjudication for NIW, we have not seen major rule changes. And as long as you're qualified, you probably should still get an approval for I-140 for that NIW part. But in terms of the 485, we're out of luck because there is so much of retrogression, so bad retrogression. So until something is done with the retrogression, the dates move ahead. You can't really file the 485.
Thank you so much, Chand, for taking that up for Nilesh. Nilesh, thank you so much for joining us today. And if you can, please join us on call. And this goes out to everyone watching us right now. Please feel free to join us on call. Next one is Pratap. Pratap is saying, I went to US with H1B visa and I was there 50 days, but payroll did not run due to the project went on hold. And now I'm in India. Now I'm planning to go to US. So will they ask pay stubs in immigration?
Sure. I mean, the good thing is, since he's out of the country, he's not accumulating any unauthorized stay or anything. Because if you're in US and you're not working, you're not getting paid, you fall out of status. But because you left to India, so normally what happens is when you come back, you already have a visa. So at the port of entry, most of the time, what they focus on is the company you're coming back to work for, is it legitimate? And on the day you return back, do you have a legitimate assignment or not? And if you're able to prove that you have a legitimate assignment, 99% of the time, you should not have any issues. And it is very rare that they ask for pay stubs for the last few days that you worked in US at the port of entry. It is not unheard of, but they will focus more on what exactly is your project, what are you doing once you come into the country, and so on. But if they do ask you anything about the pay statements, I think you should probably be honest. You should tell them whatever is the honest answer, because in spite of that, if you're coming back into the country to work and you have not committed any fraud, you're not misrepresenting anything, you're not lying to them, they will not penalize you. So the fact that you did not have a payroll probably will not even be asked. But if they do ask and you give the factual answers, the truth, I don't think it is something that would cause them to reject your visa and send you back. The focus would, however, be more on do you really have a project now that you're coming back in? Are you going to work in the project or not? So those kind of scrutiny kind of questions you can anticipate. And as long as they don't prove any life in your answers, the fact that you have not been paid by the other employer, that should not cause any any problems in terms of your visa cancellation or anything. So my guess is, make sure you document everything when you're coming back. What exactly is your project? In case you have an end client, who's your end client, where are you going to work from? And make sure it is complying with your LCA. If it complies with your LCA and you get your documentation from your employer and what your assignment is, more than likely you should not have any issue.
Thank you so much, Chand. And there you go. I think honesty is the best policy here in the US and everywhere as well. So yes, Chand, we still have so many more questions, some in the on our Facebook groups as well, which we will take up shortly. But my next question to you is, Chand, if you can tell us about, what challenges do H1B workers face when they lose their jobs, and how does the 60-day grace period impact their ability to remain in the US?
So a couple of years back, if somebody lost their job, their H1B job, the very next day they used to fall out of status. The good thing is, at least now, there were changes in the rules. Now, if somebody loses their job, there is something called a 60-day grace period. And the 60-day grace period it's a decent amount of time. So this is the time that somebody has to find a job and that new employer has to file the H1B petition for whoever lost the job. 60 days used to be enough, but unfortunately now what's happening is we are seeing more and more challenges in people trying to find a job, because sometimes the market is shaky, and sometimes we are seeing layoffs in the tech industry, and sometimes people don't want to relocate because relocation is a very tough thing. Most of the time what people do is they try to find a job within the same city they lost their job, and so these kind of challenges sometimes are causing a little bit of a delay on when people can find their new job. So when the market was very hot and there was a lot of demand, it was not a big problem at all. But recently, more and more, we are seeing challenges where somebody is getting close to their 60-day grace period. They don't really have a new job. And the minute H1B worker loses their job, they technically don't have legal status because their employment is tied with a specific employer. That being said, until 60-day period is over, they do not trigger any unlawful presence or anything. And if they find a job, not a problem. If they don't find a job within 60-day grace period, uh, because they're going to risk that unlawful presence, what people should do is a couple of things. Either they go out of the country or look for a legal option to stay back in the country. And when we say legal option to stay back in the country, things like B1, B2, or maybe converting to H4 if your spouse is on H1B, or if they want to study and go to a school, converting to F1. So all these various kind of things can be done if they want to stay back in the country, but it has to be done before the 60-day period is up. And after the 60-day grace period, say somebody moved to a valid H4 status, down the line they have another employer. That employer is completely good to file a H1B for them. So in general, the thing is, everybody has to be cognizant about this 60-day period, and before the 60-day grace period is up, they have to make sure that they act and either change their status to a legitimate, legal, other allowed statuses, or leave the country. That being said, in terms of challenges, it's a huge financial strain because people will still have bills. They still have to pay for their cars. They still have to pay for their apartment rental or their house rental. So it's a huge financial strain. So they're looking at financial strain on one end, and then they are looking at this immigration stress on the other side. But again, if the immigration part is not handled correctly, in the future, when they apply for their future visas or when they re-enter the next time, they run risk running into an issue. So for this reason, everybody should act before the 60-day grace period is up, and do whatever is legally required. And not only that, you also have to remember that suppose your spouse is on H4, and if you are converting your status to some other status, your H4 spouse will also fall out of status. So make sure not only your status, but you're also handling your spouse's status in case you're converting to a different status. But we'll hope for the best. The best case scenario is you find a job within 60-day grace period, employer files a H1B petition for you, and that is like the best case scenario where you don't have an issue. But if not, just be cognizant that the 60-day grace period cannot be extended. It typically is not extended, and it is a hard deadline.
Thank you so much, Chand, for taking that up. And my next question would be, Chand, if you could tell us also about, how have the recent policy changes, on immigration enforcement measures affected the legal standing on F1 and H1B visa holders as well? We have been seeing a lot of chaos ever since 3 weeks now. So, what do you have to say on that?
Yeah. So again, so in terms of the H1B holders specifically, so again, so even before President Trump took office, January 18th, we had a whole bunch of new rules come into picture. So there was this modernizing and strengthening H1B regulations. So these regulations were were actually passed in December, and they became effective on January 18th. And so, what this means is these new regulations gave the new administration some more ammunition on looking at H1B applications, H1B petitions a little bit differently. So, the new rules require client letters, the new rules require project documents, they require contracts, and so on, especially when somebody is a third party or a services kind of a company. So we initially thought that because of these new regulations, things will be very, very tough and so on. But again, what we are seeing in terms of approvals, because we've seen a lot of approvals in the last 1 2 weeks, H1s, what we're seeing is as long as proper documentation is done, and the employer, they are documenting what that assignment is, they're documenting what the project is, and showing the bona fide nature of the project. And what that means is submit the purchase order. The purchase order makes sense. The purchase order, even though it is short term, at least it shows that on the day of filing you do have a valid assignment. If you at least take care of those basic precautions, at this point of time, you're not seeing major issues. All the chaos that we're seeing is more on the arrests and the deportation of people who have been in the country illegally. But in terms of the H1B applications, at this point of time, I've not seen any major denials or anything of that sort. That being said, we just heard that the whole Dropbox procedure in India is getting changed. And till now, people have been getting the Dropbox appointments, interview waivers where they don't have to go for an interview. It was a little bit more lenient. And starting today, we are hearing of so many people's Dropboxes being cancelled. And what they're saying is the reason for that is if they don't have a valid visa, H1 visa, or a visa that has expired in the last 12 months, for example, and in the same class of visa, the consulates in India, they are forcing people to come for a visa interview. And this is something we just heard. And since morning, I've been getting a lot of phone calls about this. So I think in the next couple of months, things probably would change. But again, the major change that I've seen, at least in the last 1 week, that is directly going to impact H1B folks, I think, is the news about Dropbox. So we'll have to see how the Dropbox appointments will be continued. But in terms of H1B, again, client letters have become pretty important. Vendor letters, contracts have become pretty important. So the burden is a little bit higher on the employers filing H1B petitions because now they have to spend more time in preparing their documentation. But in terms of denials or anything of that sort, I have not seen any major changes. And going back to the F1 visa holders. So F1 visa holders, again, we've been seeing OPT RFEs, STEM OPT RFEs. But again, this has started almost in the last 7 8 months. Like 1 2 years back, it was very rare to see an OPT RFE or a STEM OPT RFE. Nowadays, we are seeing more and more of STEM OPT and OPT RFEs. And what that means is every F1 student who is pursuing their practical training, OPT or CPT or any of these programs, you do have to make sure that you're following the terms of your OPT or CPT. So carefully document your employment. For OPT, we're constantly seeing RFEs asking about show us your bank statements, show us your project documents, show us your pay statements, and all these things. And if somebody has some weird cash deposits in your bank account, USCIS is very, very specifically asking for an explanation. So everybody should make sure that every transaction on the bank statement is explainable. And because nowadays it has become a very common RFE where they issue a STEM OPT RFE or an OPT RFE and ask for bank statements. So just be cognizant of your rules. And I think as long as people have that evidence, they can prove their case. But definitely, I think we're seeing an uptick in OPT RFEs and STEM OPT RFEs. And at this point of time, I think we just hope that things are smooth. And I do think that things will be smooth as long as people are maintaining the documentation and following the rules. So a lot of times people don't maintain the documentation, and that is what I tell people when you are communicating with your employer. For example, you're an OPT, you're doing training, whether unpaid or paid training. If you don't even have any communication with your employer, tomorrow it is very hard to prove what you have done. So always maintain proper communication with your employer, document it, and keep that evidence. This evidence is very, very, I mean, regularly being asked in either a STEM OPT RFE or OPT RFE. Sometimes even when you apply for your H1B, when you apply for your H1B from F1 to H1B, change of status, seeing F1 RFEs is very, very common. So the bottom line is maintain proper documentation on your side, maintain proper evidence on your side. Even though you get an RFE, you'll be fine.
Thank you so much, Chand, for taking that up and for giving us those tips. So take care, friends. Play safe. And now, Chand, since we're running short of time, we'll quickly head on to our questions from Facebook and our YouTube channel as well. So if you can, please patiently respond to them as well. This first one,
Sure.
control. If you can zoom in a bit, please. I joined a US company in May 2022 on L1A visa, and now I approach my 3 year renewal. I am concerned about the impact of my limited US stay, having spent only about 7 months in the US while working remotely from other countries. On my L1A renewal under the blanket petition, whether my full US tax compliance despite remote work strengthens my case, and whether applying for renewal in India, where my initial L1A was approved, or the UK, where I'm also eligible to live, would be more favorable to minimize risks or denials or administrative delays. I'm concerned about the extension and L1A renewal. Please suggest where I should get the renewal from. I applied for UK Embassy for now.
Sure. And I think this is a common question even for some people who are on H1B. I think the question is he got an L1A approval, but he only worked in the United States only for 7 months. And after that, he went back, he went out of the country and he was working at his parent company abroad. Uh, I've seen a lot of H1B folks also do the same thing, especially from some big consulting companies where sometimes they come on H1B, they work for a couple of months, they go back to India and start working at their parent company and not stay in US for the entire 3 years that they got an approval. Again, so the rules are for something like this, it's pretty easy. For the time they are in US, if they did follow all the rules, they did work as per the terms of their approval, it does not matter that they did not complete their entire 3 years in US, but they have not violated any immigration rules in the past. Now, because the petition is about to expire, the employer is about to file an extension. So as long as the extension petition, the petitioner has a legitimate and a bona fide job opportunity, they have a requirement. If that is the case, they file a case, he should not have any problem. So the whole scrutiny would be, okay, you're applying for an extension, you're asking for 3 more years. Do you really have a bona fide opportunity for this person to work in US office for the next 3 years? And if the answer is yes, typically USCIS will not have a problem because this beneficiary, he has not violated any of his status requirements, so he'll be fine. I mean, again, L1A is a very high standard non-immigrant visa, because a lot of folks on L1A, they can come and apply for EB1C. So L1A is like somebody is like pretty highly qualified, and again, the extension petition is strong on its own merits. I don't think him not working in the country for the entire 3 years is going to cause any problem. And that being said, he can apply for a visa wherever he's currently located at, and I'm guessing he's in UK right now, so he is good to go for UK embassy for this extension part.
Perfect. Thank you so much, Chand, for taking this up. This next question is from another user. This is also on our YouTube channel. This is saying, quick question. What would be the RFE for someone who's working or job duties isn't much related to their master's degree? Would that be a specialty occupation? My company gives very detailed job duties, roles, responsibilities, qualifications, etc. The only issue is my master's degree in information systems, MS with data, SC courses, and my job is network engineering. However, I have STEM OPT, Indian work experience 2 years, BTech in CSE, computer science engineering, I guess, approved. And is specialty occupation is judging the role by company or the candidate who's applying? Seems like USCIS judges the role rather than candidates.
Sure. So I think what the employee is asking is, I have a degree in information systems and a BTech in CS, and the job is in networking. Uh, I'm at risk for specialty occupation RFE. So there are two things that USCIS looks for. One, the specialty occupation, whether the job duties are specialty occupation duties or not. And what they're looking for is the company has a requirement. So they're going to look at the company's requirement, the job duties. And what USCIS wants to understand is, for doing these job duties, do you require a degree in a specialized field? So that is where the initial inquiry would be. And if the job duties are detailed, and in this case, it looks like the job is that of a network engineer. So to me, a network engineer on a high level, for entry level, you do require a bachelor's degree. So to me, the risk of a specialty occupation is low. But again, if USS is not satisfied with the job duties, we typically get a specialty occupation RFE. And then the next part is about the employee. Is the employee actually qualified? So again, the way USCIS does their thing is, they look at something called occupational outlook handbook, and they look at this particular profession. So in this case, if it is network engineer, they open up that occupational outlook handbook, they look at the occupation, and they see what is the degree requirement. And normally for this, the degree requirement is computer science, information systems, or something very closely related to the field of computer science or information systems. And if occupational outlook handbook also says the same thing, the next thing is they'll look if the employee has that degree. And in this case, the employee has a bachelor's degree and also has a master's degree. So definitely the employee is qualified. So on a high level, I think the case is strong. That being said, if USCIS is not happy with the job description, they issue a specialty occupation RFE. If they feel the employee is not qualified, they issue something called a beneficiary qualification RFE. In this case, based on the facts that we see, I think it is low risk.
Thank you so much, Chand, for taking this up for Shreya. Next question on the screen, please. Control, if you can display. Um, I am holding a valid H-1B visa with me, and the stamping was completed back in November 2024. Now, if I plan to switch to a new employer, then will my current visa be revoked by my existing employer, or can I utilize my existing H-1B visa to find a new employer from India? I have not traveled to US yet. I am still in India and I'm exploring the opportunities to utilize my visa and make it work. This is Akash Verma.
So, in general, the H1B petition, the H1B approval that USCI is granted, that can be revoked by the employer. The visa, on the other hand, visa is issued by Department of State. It is issued on your passport, and the visa can only be cancelled either by CBP or Department of State. The employer cannot cancel your visa. So, on a high level. So, if you want to explore and try to get another opportunity, your new employer might be able to file a H1B for you, and it could be approved if it stands on its merits. But as far as your ex-employer is concerned, they cannot revoke it.
Okay, that is for Akash Verma. Thank you so much, Chand, for taking that up. And our next question is also on the screen. This is from our Facebook group. I will be traveling from the US to India. I possess an H4 visa while my husband holds an H1B visa and is currently in the process of changing jobs. Will the H1B transfer cause any issues when re entering the country?
So typically, when somebody has a H4 visa, it is not tied to a particular employer. And so what again does happen is, the husband, the spouse has to be in a valid H1B status. So if the spouse is in a valid H1B status during transfer, the same old H4 visa that has a different employer name, different petition number, that is still valid as long as it is active. So normally, what that means is, when somebody does a transfer, you don't have to go for another H4 visa stamping. Typically, it should not be a problem.
Thank you so much, Chand, for taking that up. Now, our next one is on the screen. I think this is also on YouTube, sorry, on Facebook. Prashanthi is asking, can someone please share how much time it would take to move from H4 visa to F1 again? Is there any premium processing for that? Thank you.
Sure. So the good news is, there is premium processing if somebody wants to move from H4 to F1. So what they do is they file something called a I-539 application. And when you file your I-539 application, what you do is you submit the I-20 from the school where you got the admission. You also submit proof of your SCVP payment. So you have to pay to SCBP. So you submit that proof, the I-20, and you file this application called I-539. And when you file this I-539, luckily there is premium processing. So you do that in premium, and in premium it is 30 days. 30 days they will take a decision, either an RFE or an approval, and so on. So definitely you should be able to utilize and get a quick answer if you do it in premium.
Thank you so much, Chand. And with that, we have taken up most of the comments and questions we wanted to take. But yes, it was such a great session, Chand. Would you like to tell us maybe or any end notes on this topic we have today, and maybe leave folks out there with some hope, especially those who are in so much doubt or are so sure to get deported?
Sure. Sure, sure. And again, I think the big thing is, I think everybody should always focus on complying with the rules of their visa requirement. And that being said, I mean, I don't see people, F1 students getting arrested, H1B people getting arrested. And again, the social media is full of a lot of news, and we deal with a lot of non-immigrants as a part of our daily work. And again, what we are seeing is we are seeing people who have committed crimes. They are being targeted, and when they are targeted, and when these ICE officers go, if there are people beside them who are also not maintaining status, yes, they're getting impacted. But the focus is on people with criminal offenses, and what that means to all is, as long as you don't do any kind of a crime, your risk is low. And next, if you always comply with the rules and regulations, your risk is zero. So don't associate with anybody that might have a criminal background. I mean, again, stay away from people who might have a criminal background. Don't be near them, because all the arrests that I've heard uh, are people. I mean, some people with criminal background were targeted. Like there is some restaurant, and the people found out that there is one guy with some criminal background working, and ICE targeted them. And when they come, they don't stop with that one person. They go and check everybody else's status. So the bottom line is, F1 students do not do any kind of unauthorized employment. Again, ensure you're enrolled in full-time study. H1B folks, always make sure you're working, you're getting paid, and if you're not getting paid, always make sure you know the rules, and you know your uh, I mean, again, the dual has very strict rules on what the employers can do and what they cannot do. Benching is completely illegal. Employers cannot bench. At the same time, employees have to work. They cannot say that they're going to stay and not work, and take a long, long vacation without any proper reason. So always, if people are complying with the rules, and again, I don't think President Trump's administration is really going after people who have legal status. They're more interested in people who don't have legal status and people with criminal background. Okay, so when you talk about F1, H1, these are people with legal status. I don't think these are the kind of people that will be impacted majorly. But bottom line is, all of us needs to understand that rules are important and compliance is super important.
Absolutely. Very well put, Chand, and very rightly wrapped, I would say. Thank you so much for joining us today. It was superb having you here, and I'm looking forward to having you back once again very soon, I hope. And I hope, yes, Chand.
Yeah, thank
Thank
you,
you so much,
Nipasa.
friends. And you can also contact Attorney Chand Parvathaneni, and his number is, you can note it down, it's also on the screen, 817 You can also email Attorney Chand at law@spblawfirm.com, and go visit www.spblawfirm.com to get to know more about Attorney Chand and their law firm. So, and let me tell you, friends, you should not forget to subscribe to us. Hit that bell icon. We are Immigration Talk Show on YouTube, and we're also on LinkedIn, Facebook, and on X as well. So check us out, follow us, connect with us, and you can also get in touch with me. All you have to do is message me here in this number, or you can WhatsApp me. This is also my WhatsApp number, 408-335-6444, and my email address is nipa@staffingly.com. And so with that, I would say thank you so much for joining us with your questions and comments. Yes, please do not forget to like, share, and subscribe to us. So have a great day, everyone. Thank you so much, Chant, once again. You have a great day as well.